Good afternoon, my name is Kinsalatan from semester 3 of the Bachelor of Laws program. This presentation today seeks to critically evaluate the effect of essential elements of formalities towards the independent rights of landowners towards their properties, and according to the article by Patricia Critchley, it suggests that it is of important relevance to landowners with respect to law transactions as well. Without further ado, what are formalities? Formalities are described as a legal need for matters of substance to be codified in a precise way in order to have legal ramifications. In a legal concept from early Bavaria, the conveyor had to strike a small boy at the side of the head in order for the real property transfer to be lawfully completed. In England, on the other hand, there's a statute called the Statute of Frauds, in which certain legal contracts, particularly those involving the transfer of land, had to be in writing, signed by the transferor or by someone else in the testator's presence, and under the testator's direction, attested to and subscribed by the testator. And all of these had to occur in front of 3 or 4 witnesses. In lay terms, formality is adhering to conventions or proper manners in a way that it is often more symbolic or emblematic than necessary. Let's take this analogy for example. When there is a big gathering of some sort, no one will start eating until everyone is seated or until everyone is served. This formality of dining etiquette demonstrates a statement of politeness and consideration for others. According to Patricia Critchley, it is implied that formality is not a fundamental component of the transaction, but rather something that it is imposed on or external to it. However, it will be beneficial for our definition to communicate the idea that formality is more of an essential element, since in legal usage, formality is typically also considered as a requirement rather than merely a habit or convention. With that, when we talk about formalities, we naturally look into the Statute of Frauds 1677, which was mentioned previously, and now we look specifically into Section 7, which relates to formalities when creating trust of land. In Section 7, it states that any declarations or creations of trust of confidences involving lands, tenements, or hereditaments must be manifested and proved in writing, signed by the party who is legally required to make the declaration, or by his last will and testament, or else all of these will be completely null and useless. In relation to the passing of the statute, the need for formalities to prevent fraud and perjury has frequently been attributed to the changes in the law relating to evidence and process. Moreover, changes in conveyancing law and practice falls yet under another group of legal developments that were important to the passing of the statute, in which many aspects of the statute, notably those relating to trust, can be seen as a reform of the conveyancing laws in response to these changes. In the modern form, it is now found in Section 53, subsection 1, subsection B of the Law of Property Act 1925, in which declaration of trust pertaining to any land or interest therein shall be expressed and shown by some writing signed by some person who is able to declare such trust, or by his will according to the modern law today. By this definition, in the modern legislation, the interpretation of Section 7 was finalized, and its main concerns are evidence and proof rather than truth or virtues. The difference here was also the fact that the statement need not be put in writing and thus can be orally made, which is one of the distinctions between the Statute of Frauds and this section from Law of Property Act 1925. These provisions are seen as restrictive, as it comprises the landowner's personal autonomy to transmit his proprietary interest in the way that he sees fit. For example, in the case of HSBC Trust Company Limited and Quid. Despite them following the other formalities, the claimant still could not acquire the freehold, as the court determined that the claimant's document as not a deed just due to its unclear phrasing. Other than that is the case of Sharma and Simposh Limited, where the court firmly voids the entire agreement because it did not meet the requirements for former validity. Although the statutes may seem constraining and burdensome towards the landowners, formalities have aided in fostering clarity, protecting the interests of the seller and buyer in a real estate transaction, as well as fostering consistency and predictability in the application of land laws. With that being said, we must evaluate the benefits and detriments brought by the presence of these formalities. Professor Fuller has suggested that legal forms or formalities can serve three purposes. The first being also the most obvious advantage, which is the evidentiary purpose. There are many ways to satisfy the demand for evidentiary security, such by requiring a writing, an attestation, or the certification of a notary. The reasoning behind this is to remedy situations where memories may no longer be accurate and parties to the transaction may require proof of the existence and conditions of the transaction for their own use in resolving disputes or disagreements later on in the future. Moreover, formality can serve as a cautionary purpose by checking against inconsiderate behaviors. In relation to that, it aids in preventing parties from engaging in a transaction that, unknowingly to them, has legal implications, in which also provides the customers the opportunity to look into the effects of their choices so they can decide whether or not they want to move forward with the transaction whilst being fully informed. Lastly, the final and the most important advantage would be the channeling function, which is basically a test of enforceability for agreements. In order to comprehend this channeling function of form, perhaps the most useful analogy is that of language, which demonstrates both benefits and drawbacks of form in the context we are discussing now. Despite these advantages, there are disadvantages or detriments as well, such as unfairness and injustice towards people who are ignorant of such formalities, and therefore an accidental non-compliance with the formalities. This raises the question whether parties should be expected to have this knowledge or not. Furthermore, it also amounts to extra trouble and cost. In conclusion, it is apparent that the benefits outweigh detriment towards formalities. Fundamentally, formalities are attempts to get results that maximize a set of competing purposes by the mechanical application of rules that are formulated in a substantively rational manner. As a side note, in cases where a landowner expressly or implicitly promises the claimant a right and that they may have it without formality, and thus becomes unconscionable as claimant had replied on it. Estoppel can be the counterpart to formality rules in land law. Thus, estoppel is an exception to formality rules in land law. Therefore, as a recap, land law has traditionally relied heavily on formalities to achieve a variety of policy goals, in which they alert the grantor to the legal effect of the instrument, protect the grantor from external pressures, prompt term clarification, and evidence the grant, and many, many more. All in all, the requirement of formalities thus indeed detracts autonomy from landowners in dealing with their own land and properties, but with good reasons, which benefits the society, as without the formalities, transactions would be complicated and confusing. This is all from me. Thank you.